So, dear students and dear online participants, welcome to this lecture. And it is really my great pleasure to introduce to you my colleague, Mariolina Eliantonio. She's a professor of European and Comparative Administrative Law and Procedure at this faculty. And she's also the co-editor of the Research Handbook on EU Environmental Law. And actually, this lecture series is a kind of a spin-off of this Research Handbook that has 30 chapters in total. So many of the authors of the chapters contribute to a lecture. Mariolina also wrote a chapter to the Research Handbook. Today, her lecture will focus on access to justice in environmental matters before the national courts. And I give you the floor, Mariolina.
Thank you very much, Marianne, for the kind invitation. Thank you all very much for being here this afternoon. Thank you also to those who are joining online. And to start with, I think you should see this lecture as a bit the twin brother or sister of last lecture that was delivered by Ioanna Adigianni. She focused on access to justice in respect of the EU courts, and I will focus today also building up on her insights on access to justice in environmental matters in national courts. So the two perspectives will be complementary to each other. Now, where do we start from in order to understand the idea and the relevance of the question of access to justice before national courts? We need to start from the idea and the notion of the Aarhus Convention as a mixed agreement. You are all familiar, of course, until now, throughout the lecture series with the Aarhus Convention and its relevance and its content. What is important to focus on today to understand why we are talking about access to justice before national courts and the Aarhus Convention's relevance therein is because of the nature of mixed agreement for the Aarhus Convention. So what does it mean that the Aarhus Convention is a mixed agreement? It means that it is binding on the EU and its member states. And in as far as the EU is concerned, it is binding for the EU itself and for the member states as a matter of EU law. So where we need to start from to understand the notion of a mixed agreement is the fact that in environmental matters, the EU has competence that is shared with the member states. This means that both the EU and the member states can, as a matter of international law, enter into international agreements. And this is the case with the Aarhus Convention. The Aarhus Convention has been signed by all the member states of the EU as actors in international law and by the EU as a supranational organization. Because the environmental policy is a shared competence between the EU and the member states, it is both the EU that is responsible for this policy area and the member states. And as a consequence, the Aarhus Convention is binding on the member states, both as a matter of international law, because themselves they signed the Aarhus Convention, and as a matter of EU law, because they are party to the EU, which in turn is a signatory to the Aarhus Convention. And in the signing and the ratifying of the convention, the EU has pledged that it would itself respect the convention and it would ensure that member states respect the convention, which means that the pillars of the Aarhus Convention, and in particular, the third pillar, access to justice, needs to be respected by the member states as a matter of international law, but also as a matter of EU law, because the EU is bound to the respect of the Aarhus Convention. This brings us to the relevance of the question of how and to what extent the member states of the EU, as member states of the EU, respect the third pillar of the Aarhus Convention. and how the EU has, let's say, taken step to ensure that the member states respect the convention. This notion of access to justice before national courts is important in the framework of the EU multi-level judicial system for two reasons. The first is because EU environmental law is overwhelmingly implemented through national measures. So EU, the environmental law, which is adopted by the co-legislator at the EU level, is overwhelmingly implemented through a system of so-called indirect administration. It is the member states' authorities that transpose directive, operationalize EU legislation by designating competent authorities to apply and subsequently enforce EU law. So EU environmental law is first and foremost a matter for national authorities. And in the EU multi-level system of judicial protection, when national authorities violate EU law, it is first and foremost national courts that are competent to oversee the possible violation of EU law by national authorities. Therefore, it is of importance that access to justice in environmental matters is ensured at the national level, because national courts are the first and main enforcers of EU environmental law. Of course, as last lecture has shown, there is some amount of EU environmental law that ends up adjudicated before the EU courts. But already from a quantitative point of view, it is national courts that are at the forefront of protection of EU environmental law. Secondly, as it has emerged from last week's lecture, or a couple of weeks ago's lecture, last lecture in any case, direct access to EU courts, so access to justice before the Court of Justice of the European Union, is until now extremely restricted because of the way in which the Court of Justice has interpreted the standing requirements that arise from the action for annulment under Article 263 of the TFEU. As a counterbalance for this very restrictive approach to direct access, the Court of Justice has consistently held that despite the restrictive access at EU level, there is no gap of judicial protection because there will always be indirect access through national courts and the preliminary question of validity under Article 267 of the treaty. So again, the role of national courts is paramount in this context and in the imperative to protect access to justice, because access to EU courts is limited. Hence, the only way to bring a matter of relevance for the EU courts is indirectly through the national courts. As a consequence, it is imperative that access to courts at the national level functions properly in order to ensure the supposedly complete nature of the system of remedies in place at the moment in the EU. So having now introduced the importance and the relevance of the topic of access to justice before national courts, what I want to go further into is look first at how the Aarhus Convention conceptualizes and requires access to court under Article 9, and subsequently how the EU has transposed these requirements in as far as access before national courts is concerned. So as you know already, probably Article 9.1 concerns access to justice for alleged violations of the provisions of the first pillar of the convention, so access to environmental information. Article 9.1 concerns access to justice for violation of access to information provisions. Article 9.2 concerns access to justice in the context of projects that are covered by the public participation requirements of the convention, so the second pillar of the convention, namely projects that have a potential significant effects on the environment. So Article 9.2 concerns access to justice in the context of projects that fall under the public participation requirements foreseen by the convention. And Article 9.3 concerns instead access to justice for all violation of environmental law. In our story, EU environmental law. Why the asterisks? Because while under Article 9.1 and Article 9.2, access to justice is taken to mean under the convention access to a court or another independent and impartial body, so court or court-like bodies. Under Article 9.3, access to justice is fulfilled, the requirements of 9.3 are fulfilled, so long as contracting parties provide access to a court or an administrative authority, so not necessarily a court-like body. So these are the three sub-pillars, if you wish, of Article 9, the third pillar of the Aarhus Convention. Access to justice for violation of access to environmental information provision, access to justice in the context of projects covered by public participation requirements, and a residual provision on access to justice for all environmental law violations. Before we move to a discussion concerning how the EU has transposed these requirements under Article 9, there is one point that is necessary and one clarification that is in order. Namely, that access to justice entails several aspects. The first one is who goes to court. So access to justice is about who gets standing, who are the applicants that will eventually get to plead their case before the court. This is admittedly probably the aspect of access to justice that is the one that we would most commonly associate with the notion of access to justice. It's about who goes to court. But provisions on access to justice also concern the costs of the proceedings. So this is not about who goes to court, but how much the proceedings costs. There are requirements in the access to justice provisions of the Aarhus Conventions about the cost of the proceedings. And in particular, the convention requires that costs of proceedings under Article 9, so to litigate potential violations of EU environmental law or of environmental law more in general, they should not be prohibitively expensive in order not to, of course, dissuade environmental organizations from going to court, from accessing the court. Access to justice also concerns the scope and the intensity of review. So it's about in how far and in which depth courts review environmental decisions that are made by the public authorities. And in this context, the Aarhus Convention requires that national courts be able to carry out a review that concerns both the procedural legality and the substantive legality of an environmental measure. So courts need to be able to both look at how this decision came about, but also what is the content of this decision. And finally, access to justice under the Aarhus Convention also concerns remedies. So what kind of remedies can judges award? What are the powers of the judges once they have established that a violation of any of these provisions of environmental law has been violated? And the convention in this context requires that there be adequate and effective remedies. So also rules concerning the powers of the judges to award certain remedies fall under the scope of the access to justice provisions of the Aarhus Convention. After this general introduction on access to justice in the Convention, this presentation will continue focusing on the first point. So rules on standing and rules about who can go to court to litigate violations of environmental law. So focusing now on the EU, how has the EU implemented the Aarhus Convention, once more, in as far as the member states' courts are concerned? So I will not talk here any further, or at all, in fact, about the Aarhus regulation, which has been already the subject matter of last lecture, but about the implementation, or rather maybe the lack of implementation, as we will discuss in a moment, of the Aarhus Convention in as far as the member states' courts are concerned. The first sub-pillar, let's say, of Article 9, so Article 9.1 of the Convention has been transposed through the so-called Access to Environmental Information Directive. The second pillar of Article 9, so access to justice in the context of projects that are covered by the public participation requirements of the directive, has been transposed through the so-called Public Participation Directive. Now, this, while the first directive is in itself a directive that contains the entire legislative framework on access to environmental information, including access to justice, the Public Participation Directive is one that went to amend existing directives. And in particular, it went to amend the directive on environmental impact assessment and the industrial emissions directive. So these two directives acquired an access to justice provision through the adoption of the Public Participation Directive. So the Public Participation Directive served as an amendment to these two directives. Why these two directives? Because these directives regulate projects that fall within the scope of Article 9.2, because they concern projects that have a big environmental impact, a potentially significant environmental impact, and therefore fall within the scope of application of the public participation requirements. When it comes instead to Article 9.3, so the access to justice requirements for all violations of environmental law, there is at the moment no horizontal transposition of this sub-pillar of Article 9. What we have at the moment is two pieces of soft law, a Commission notice and a Commission communication on access to justice. There are some sectoral directives that have an access to justice provision, and there are a number of proposals that are pending, which might contain, if adopted, access to justice provision. I come to them in a moment. So what I will do in the remainder of the lecture is to look at these several instruments and show how the various sub-pillars of Article 9 have been transposed at EU level through these instruments. So Article 191 of the Aarhus Convention, as I said, has been transposed through the Access to Environmental Information Directive. In particular, the Access to Environmental Information Directive foresees that any applicant who considers that their access to the information request has not been treated in accordance with the directive should have standing before national courts. So in this sense, the Access to Environmental Information Directive very faithfully reproduces the requirements under Article 9.1. And the only case that came before the court with respect to this specific provision of the directive is the fish legal case, in which the Court of Justice clarified that there is no need for an applicant to prove an interest in the content of the information that they have requested. If an applicant claims that the access request has not been treated in accordance with the directive, this is enough to grant them standing. So it is a rather generous approach to standing, both in Article 9.1 and rather faithfully transposed at the EU level. When it comes instead to the public participation directive, the directive foresees access to justice for the members of the public concerned who can show either the impairment of a right or a sufficient interest in the subject matter of the dispute, thereby, again, reproducing the two models of standing that are foreseen in Article 9.2 of the Convention. This provision that, as I mentioned, has gone to amend the EIA directive and the Industrial Emission Directive has been subject to a relatively large amount of case law where the court has had to interpret, first of all, who are the members of the public concerns? And second, what does it mean that standing is only granted to those members of the public concern who can show the impairment of a right or the existence of a sufficient interest? More in particular, it is the notion of impairment of a right that has generated the most case law, together with the idea of the members of the public concerned. In particular, in the Djurgården case, the court clarified that by members of the public concerned, also, if you wish, small NGOs need to be included because a numerical requirement for NGOs is in itself acceptable, but it cannot be so restrictive to run counter to the aim of the convention to ensure a broad access to justice. So member states are allowed to set rules on who are the members of the public concerned, but they cannot set numerical requirements which are so strict as to run counter to the imperative of broad access to justice. This case was followed a couple of years later by the Trianel judgment and several years later by the Gruber judgment, both coming from the Germanic tradition of standing, the first from Germany, the second from Austria, where the court clarified that member states are allowed to grant access to justice subject to the fact that NGOs are able to prove that there is the impairment of a right that has been violated, but also this criterion of impairment of a right cannot run counter to the imperative to ensure broad access to justice, meaning that if NGOs would have to prove that their own personal rights has been violated for them to be able to go to court, this would essentially nullify the possibilities for them to ever claim the violation of environmental law. Such a requirement would run counter to the imperative of broad access to justice. So the Court of Justice in these two cases severely limited the national rules which were based on the impairment of a right, the violation of a right criterion as a criterion for access to justice. And as I mentioned, this is the case in the Germanic traditions of environmental or administrative law, more particularly in the German-Austrian tradition. More recently, the court had the chance to also clarify further what it means members of the public concerned who have access to justice, and clarified in a case that came from the court of this city, actually, and from a former scholar of this faculty who is working currently in the court of Maastricht. The court clarified that access to justice must be guaranteed even if an NGO did not take part in the preceding decision-making process, meaning that member states cannot restrict access to justice only to those members of the public concerned which participated in the administrative decision-making process which led to the decision under challenge. This kind of measures, again, would run counter to the requirements to ensure broad access to justice. And more recently, the Court of Justice clarified even that access to justice under Article 9.2 of the Convention needs to be ensured also for cases that are beyond the scope of application of the Public Participation Directive. In this case, the Habitats Directive, which did not contain an access to justice provision through the Public Participation Directive. The Court of Justice argued that because the Habitats Directive contained certain participation requirements, Article 9.2 was triggered, and therefore access to justice under Article 9.2 had to be ensured. So all in all, the Court of Justice has had the chance through a number of preliminary questions to clarify and also to some extent expand the scope of application of Article 9.2 and the Public Participation Directive. As I said some minutes ago, the third pillar of Article 9, access to justice for all violation of environmental law, had a very different destiny from Article 9.1 and 9.2 when it comes to the transposition at EU level for member states' courts. Because in 2003, there was a proposal for a directive on access to justice, but this proposal never made it to the decision-making or through the legislative process. It was blocked in council for a number of years. It was eventually withdrawn from the legislative agenda. And several years later, when the debate on the transposition of Article 9.3 was revived, the Commission, despite the advice of a number of scholars who opted or who argued that a hard law, a directive, was necessary, akin to the Public Participation Directive, nevertheless, the Commission decided to go for a soft law approach. So they issued a so-called Commission notice on access to justice in 2017. And they reinstated what we more or less already knew before this Commission notice, namely that member states can enact rules on standing, so they may adopt criteria that individuals and NGOs must fulfill in order to obtain standing, but these criteria must not make it impossible or excessively difficult to exercise the rights conferred by EU law. This is not adding anything to the existing body of knowledge and of case law, as because of the principles of national procedural autonomy as limited by the principles of equivalence, effectiveness, and effective judicial protection, it was already clear from a long-standing case law of the Court of Justice that member states may not adopt procedural rules that make it impossible or excessively difficult to enforce rights under EU law. So in that sense, the European Commission notice of 2017 simply reinstated and reiterated what the case law of the Court of Justice beyond environmental matters had already clarified and solidified already for a number of years. So in that sense, in as far as Article 9.3 is concerned, the ball was at that point in the court of the member states to examine their own national procedural rules on standing and assess whether they were too restrictive to comply with this threshold of impossible or excessively difficult. The Commission eventually also built further on the soft law approach by issuing some years ago a communication where they essentially concluded that there is no future for an horizontal access to justice directive, but they rather hope for a sectoral approach. So they encourage the co-legislator to support access to justice rules to be included in sectoral EU proposals. There are at the moment a number of proposals pending on water legislation, soil, waste that contain access to justice provisions. And the Commission is now calling the co-legislator on supporting these provisions as inserted by the Commission in these proposals. It also asks the member states to remove all the remaining obstacles in national law in line with the Court of Justice case law. So again, throws the ball back in the courts of the member states for them to examine their own national procedural rules and assess whether they render too hard, essentially, the enforcement of EU environmental law. And it calls national judges to improve access to justice to the extent that they are able to, via the tools that they have at their disposal, namely the principle of supremacy, direct effect, and indirect effect. And the Commission reinstates in this communication that it will continue to fulfill its role as guardian of the treaty through enforcement actions. So it will continue to examine national rules and possibly bring infringement proceedings when it considers that certain rules falling under the scope of Article 9.3 are too restrictive to comply with the Convention. In the meantime, as I said, the ball was in the courts of the member states. Well, some member states' court have actually done their job of checking their own national procedural rules against the requirements of Article 9.3, and a number of preliminary questions have been sent to the Court of Justice. The first one, and possibly the most fundamental of them, is the LZ1, so the Brown Bear case, number 1, where the Court of Justice asked whether individuals could rely directly on Article 9.3 in a national court in lack of transposition of Article 9.3, replied in the negative. because, according to the court, Article 9.3 does not have direct effect. It cannot be used directly by individuals before national courts. However, the Court of Justice imposed a duty of consistent interpretation on the side of the national courts. So national courts have an obligation to interpret their own national rules on standing in a way that is as much as possible in line with the convention, and therefore in a way that is as much as possible able to allow standing for environmental NGOs. So no direct effect, but a duty of consistent interpretation flowing from Article 9.3. Then the Court of Justice went on in a number of cases, including very recent ones, to clarify and expand even more the scope of application of Article 9.3 and when standing for environmental NGO needs to be ensured. In Protect Nature case, for example, the Court of Justice clarified that this requirement to ensure standing arises also when an NGO is claiming the violation of the Water Framework Directive. So also in water legislation, NGOs must be able, under Article 9.3, to go to court to claim the violation of EU environmental law, in this case, EU water legislation. In Deutsche Umwelthilfe, the case concerned EC type approval for vehicles, again, a matter that falls under Article 9.3 of the Convention. And again, the Court of Justice concluded that NGOs who claim the violation of these rules must be given access to court. In another German case, the Court of Justice concluded that also when it comes to national action programs that are aimed at fulfilling the targets imposed by EU law when it comes to pollution from nitrates, so soil legislation, also access to justice needs to be ensured. And finally, in an infringement proceedings brought by the Commission against Poland, the court ruled with respect to forest management plans that are required under EU law. And again, also when an NGO claims that these plans are being violated by national authorities, they must be granted access to court, notwithstanding national procedural rules that might limit this standing. I come now to some conclusions. So when it comes to Article 9.1 and its transposition at EU level, the Access to Environmental Information Directive, what research has shown is that there is overall compliance when it comes to standing requirements, and there is little case law on this matter, and one can argue there is also little need for case law because the requirements are generous, both at the convention level, at the EU level, and in their transposition at member state level. When it comes to Article 9.2 and its transposition at the EU level, the Public Participation Directive, research has been carried out, which has shown that in general, member states have correctly transposed the standing requirements under the Public Participation Directive. When this has not been the case, in general, these cases have come to the attention of the Court of Justice. So national courts have brought question to the Court of Justice, claiming that their own national procedural rules did not constitute a correct transposition of the standing rules under the Public Participation Directive. Mostly, as I said, to clarify what the notion of impairment of a right means and what the notion of members of the public concerned entails. Finally, when it comes to Article 9.3, the picture today is a lack of horizontal transposition through an access to justice directive, a soft law approach by the Commission, And all of this has generated a duty of Aarhus-friendly interpretation for national courts. So a big burden, if you wish, on the national courts to consider and assess their own national procedural rules against the requirements of the convention, an increasing consequent intervention of the Court of Justice by national courts who don't know whether their national procedural rules comply with Article 9.3 and therefore send questions to the Court of Justice, which has increasingly clarified the scope of application of Article 9.3. And I think a quite clear future of Article 9.3 or future for the transposition of Article 9.3 through sectoral legislation. Many of those, apart from 2 directives which are adopted, many of these sectoral legislations containing access to justice provisions are at the proposal stage. So while the Commission can call the co-legislators to accept these provisions and ensure that there is a legislative basis for access to justice in 9.3 situations, it will depend on the political agreement struck between the Parliament and the Council and inside the Council itself as to whether this access to justice provision will make it through the final text of the legislation. As I said, all of these provisions, these proposals they date from 2022, 2023, so they will be negotiated in the months to come. So it is rather exciting to see how Article 9.3 will make it through the political process. So stay tuned for more news on access to justice before member states' courts. And with that, thank you very much for your attention.